You are listening to HOA Consequences. I wish this was exaggerated. I am standing in my side yard in Fargo, North Dakota, holding a gate latch and a padlock, and Sandra Wright is 6 inches from my face, screaming that I am a trespasser on HOA common property, and she is calling the police right now. Her voice is shrill, and she is waving a plastic ruler at the string line I put up this morning to mark where the fence crew is going to dig post holes tomorrow. The ruler has measurement markings, but she is using it like a pointer, jabbing it toward the stakes every few seconds. She showed up 20 minutes ago in a black windbreaker and a white bucket hat, clipboard tucked under one arm, tiny body camera clipped to her collar, and she started yelling before I even had a chance to say hello. She says my string crosses into the common area by 3 inches, and that is encroachment, and the rules do not care about my excuses, and neither does she. I moved to Fargo 8 months ago for work. I am an EMT dispatcher, 3rd shift, and I cannot miss calls. The house was affordable, and the neighborhood looked quiet. Maplewood Commons Association. The name made me laugh the first time I saw it on the sign at the entrance. 2 commons back to back like a typo. But nobody else thought it was funny. The HOA runs this place like a military checkpoint. Every mailbox has to be the same shade of brown. Every driveway has to be sealed every 2 years. Every blade of grass gets judged. The rules are not guidance here. They are leverage. And Sandra Wright is the safety committee chair who uses security as an excuse to harass anyone she does not like. I have a custody and visitation routine with my daughter. She is 7. She stays with me every other weekend and 2 weeknights. The schedule is tight, and the HOA keeps targeting it. They towed my friend's car during a birthday party because he parked in a guest spot without a sticker. They sent me a violation notice the day after my daughter's grandmother visited because her car was in the driveway overnight, and guest parking is limited to 6 hours. They flood my mailbox with certified letters, one after another, so I have to sign for them at the post office, or they pile up and I miss deadlines. It is harassment disguised as compliance. 3 weeks ago, I decided to put up a privacy fence along the side yard. My daughter wanted a space where she could play without the neighbors staring. The back corner of the lot is narrow and runs along a utility easement strip that the HOA claims is common area. I pulled the property survey from when I bought the house. The survey shows my lot line runs right along the edge of the pavement. The fence plan I submitted to the HOA showed posts inside my property line, 6 feet tall, black chain link, same style 3 other houses have. I paid the HOA application fee, $200, and waited. 2 weeks ago, I got a denial letter. The letter said my fence violated setback requirements and height restrictions, and the board needed a revised application with an engineered drawing and a landscape architect signature. I called the management company. They said Sandra Wright flagged my application during her safety review and recommended denial. I asked what the actual setback rule was. The woman on the phone said she would email me the guidelines. The email never came. I called back 3 times. Every time I got voicemail. I went to the HOA website and tried to log into the homeowner portal to download the rules myself. The portal was down. Error message every time. I emailed Sandra directly. She replied in all caps, which I am not going to repeat here, but the message said I should have read the rules before I moved in, sweetheart, and that compliance issues are not negotiable. I ordered a fence permit from the city. The city inspector came out, looked at the survey, measured the setback from the street and the utility easement, and approved it in 15 minutes. He said the HOA can set design rules, but they cannot override city code on setbacks. He signed the permit and told me to keep a copy on site during construction. I hired a contractor. His name is Ben, and he has been doing fences in Fargo for 12 years. He does not take nonsense from HOAs. He showed up Monday morning with his crew, looked at the stakes I put out, checked the survey, and said the line was clean. He said he would start digging post holes Wednesday and have the fence up by Friday. I felt relieved for the first time in weeks. Tuesday night, I got home from my shift at 6 a.m, and there was a new certified letter in my mailbox. The letter was from the HOA attorney. It said I was in violation of the construction approval process, and if I proceeded with unpermitted work, the association would seek an injunction and charge me for enforcement costs and legal fees. The letter said I had until Friday at 5 p.m. to submit a compliant application or face daily fines, starting Saturday at $200 per day. I called Ben and told him to hold off. He said he already ordered the materials, and his crew was booked solid for the next 2 months. If I delayed now, I would lose my spot and have to wait until fall. I told him I needed 1 day to sort it out. Wednesday morning, I drove to the HOA management office. It is in a strip mall 20 minutes away. The office was locked. A sign on the door said appointments only. I called the number on the sign. Voicemail. I left a message asking for an emergency meeting to discuss the fence application. I sat in the parking lot for an hour. Nobody called back. I drove home, and Sandra Wright was standing in my side yard. She had a clipboard with a clear rain cover, a tape measure clipped to her belt, and her body camera recording. She said she was conducting a safety inspection, and I was required to cooperate. I asked if she had a warrant. She laughed and said HOA rules give the safety committee access to all common areas and transition zones. I said this is my property. She said the survey is wrong, and the string line I put up crosses into the easement, and she is documenting the encroachment for the board. I pulled out my phone and started recording. She did not care. She walked along the string line with her tape measure out, calling out measurements to herself, writing notes on her clipboard. She got to the back corner stake and stopped. She looked at me and said the stake is 4 inches into the common area, and that is trespassing, and she is filing a formal complaint. I said the survey shows the property line. She said surveys are not binding on the HOA, and the association maintains its own plat map. I asked to see the plat map. She said it is available through a records request, and I have to pay copy fees and wait 30 days. I said that is insane. She said the rules do not care about my excuses, and neither does she. I walked away. I walked toward the front yard on purpose because I wanted her to follow and say more. She followed. She kept talking. She said I should have read the rules before I moved in, sweetheart, and now I am stuck with the consequences. She said the board is watching me, and any attempt to proceed without approval will result in immediate legal action and a lien on my property. I stopped and turned around. I said I have a city permit and a licensed contractor and a property survey. She said none of that matters because the HOA covenants override city permits, and if I do not comply, she will personally ensure the fence gets torn down and I pay for removal. A car pulled up to the curb. It was a rideshare driver waiting for a pickup at the neighbor's house. He was watching us through his window and rolling his eyes. Sandra did not notice. She kept going. She said she has the authority to issue stop work orders and tow any contractor vehicle that blocks HOA access, and she will not hesitate to use it. That night I could not sleep. I kept thinking about the deadline. Friday at 5 p.m. Less than 48 hours. If I missed it, the fines would start Saturday and pile up fast. 200 a day is 6,000 a month. I do not have that kind of money. I thought about canceling the fence. I thought about moving. I thought about just ignoring the HOA and letting them sue me. Then I remembered something. When I bought the house, the title company gave me a packet of HOA documents. Covenants, bylaws, rules, budgets. I never read them. I pulled the packet out of a filing box in the garage and started going through it. The covenant said any construction that alters the exterior of a property requires board approval. The rules said approval decisions must be made within 30 days of a complete application. My application was submitted 3 weeks ago. The denial letter said I needed to revise and resubmit, but it did not say my original application was incomplete. I kept reading. The rules said homeowners have the right to appeal any board decision within 15 days by submitting a written request for a hearing. I checked the date on the denial letter. It was dated 12 days ago. I still had 3 days to file an appeal. I stayed up until 4 a.m. writing the appeal letter. I attached a copy of the city permit, the property survey, and photos of 3 other fences in the neighborhood that matched my design. I printed it, put it in an envelope, and drove to the management office at 8 a.m. Thursday morning. The office was still locked. I slid the envelope under the door. I took a photo of the envelope on the floor with the timestamp visible. I sent a copy to the management company email and to Sandra Wright's email with the subject line, Formal Appeal Submitted per HOA Rules Section 12.4. By noon, Sandra had replied. Her email said the portal was down, and without a digital submission, my appeal does not exist. I forwarded her my photo of the envelope under the door and said the rules do not specify digital submission and a hard copy is sufficient. She did not reply. At 2 p.m., I got a text from Ben. He said his crew was ready to start tomorrow morning and he needed confirmation. I told him to go ahead. He said, "Are you sure?" I said yes. He said, "Okay, we will be there at 7 a.m. I went outside and rechecked the string line. One of the stakes had been pulled out. I hammered it back in and tied the string tighter. I stood there looking at it, trying to figure out how Sandra was going to respond. I did not have to wait long. At 8 p.m., my doorbell camera caught Sandra doing a late-night inspection patrol. She walked up my driveway with a flashlight and her clipboard, no body camera this time, and she stood in the side yard for 5 minutes taking measurements with her plastic ruler. Then she walked up to my front door and taped a notice to it. The notice was on HOA letterhead, handwritten in all caps, which I am not going to repeat here, but it said construction is prohibited, and any contractor who begins work will be subject to immediate towing, and the homeowner will be fined. I saved the doorbell footage to my phone. I went outside and took a photo of the notice. I texted both to Ben and said, "This is what we are dealing with." He replied, "Do not worry, I have seen worse." Friday morning at 6:45 a.m., I heard a truck in the driveway. I looked out the window, and Ben's crew was unloading fence panels and a post hole digger. I went outside. Ben handed me a coffee and said, "Let's get this done." His guys started marking the post locations with spray paint. No readable text, just orange dots along the string line. At 7:15, Sandra's car pulled up. She got out with her clipboard, her body camera, and a tape measure. She marched straight to the side yard and started yelling, She said this is a stop work order, and if the crew does not leave immediately, she is calling a tow truck. Ben ignored her. He told his guys to keep working. Sandra stepped in front of one of the crew members and blocked him from setting a post. Ben said, "Ma'am, you are interfering with permitted work on private property." Sandra said, "I have HOA authority to enforce compliance, and this work is not approved." I stepped between them. I said, "Sandra, I filed an appeal, and the rules say I have the right to proceed while the appeal is pending." She said, "That is not true, and I am lying." I pulled up the HOA rules on my phone and showed her section 12.6. Appeals do not stay construction unless the board votes to issue a temporary injunction. She looked at the screen and her face went red. She said the board will meet tonight and issue the injunction retroactively. I said that is not how it works. She turned and walked back to her car. I thought she was leaving. Instead, she pulled out her phone and made a call. 2 minutes later, a tow truck pulled up to the curb. The driver got out, and Sandra pointed at Ben's truck. She said that vehicle is parked in a fire lane and needs to be removed immediately. Ben said, "I am parked in the driveway." Sandra said the driveway encroaches on the easement, and that makes it a fire lane. The tow driver looked confused. He said, "Lady, I need a police authorization to tow from private property." Sandra said, "I am the HOA safety chair, and I am authorizing it." The tow driver got back in his truck and left. Sandra screamed at him as he drove away. She turned back to me and said, "This is not over." She said the board is filing an injunction today, and I will be personally liable for every dollar the association spends on enforcement. Then she got in her car and drove off. Ben's crew finished the post holes by noon. They set the posts in concrete and let them cure. Ben said they would come back Monday to hang the panels. I said thank you. He said no problem, but you need to be ready for what is coming next. I said I know. That afternoon, I got an email from the management company. The email said the board held an emergency meeting and voted to deny my appeal. The email said I had 24 hours to remove the fence posts, or the association would hire a contractor to remove them and bill me for the cost, plus a $300 administrative fee. I replied and said the posts are not a fence yet. They are construction in progress on permitted work, and the board cannot order removal without a court order. I attached the city permit and the appeal filing receipt. I said I expect a hearing within 15 days per the rules. The management company did not reply. Saturday morning, I woke up to a new certified letter. The letter was from the HOA attorney again. It said I am in violation of the emergency stop work order, and daily fines of $200 have begun as of today. The letter said the association is pursuing an injunction in district court, and I will be served within 72 hours. It said if I want to avoid litigation, I can agree to remove the posts, pay the accumulated fines, and resubmit a compliant application with a landscape architect review. I called an attorney. His name is Mark, and he does HOA disputes. I explained the situation. He said the HOA is bluffing. He said they cannot fine me for permitted work, and they cannot get an injunction without proving immediate harm. He said the body camera footage and the doorbell video are gold. He said keep recording everything and do not remove the posts. I asked him about the records request. I told him Sandra said I have to pay copy fees and wait 30 days to see the HOA plat map. He said that is a violation of state law. He said North Dakota requires HOAs to provide records within 10 business days, and they can only charge actual copying costs, not processing fees. He said if they are hiding documents or charging bogus fees that is a separate claim. I filed a formal records request on Monday. I asked for the HOA plat map, all board meeting minutes from the last 2 years, the safety committee charter, Sandra Wright's appointment letter, and any communications between Sandra and the board regarding my fence application. I said I would pay reasonable copying costs, and I expected a response within 10 business days per state law. The management company replied the same day. The email said records requests require a $50 processing fee and a 30-day review period to redact confidential information. I forwarded the email to Mark. He said that is illegal, and we can sue them just for that. He said let them refuse, and we will add it to the complaint. Tuesday morning, Ben came back with his crew to hang the fence panels. I stood outside and watched. The panels went up fast. Black chain link, 6 feet tall, exactly what I submitted in the application. The crew worked through lunch. By 3 p.m., the fence was up, except for the gate. Ben said he would install the gate Thursday once the latch hardware arrived. At 4 p.m., Sandra showed up again. This time she had 2 other board members with her. One was a man in his 60s wearing a polo shirt with the HOA logo on it. The other was a woman in her 50s with a phone in her hand recording. Sandra walked straight to the fence and started measuring the height with her plastic ruler. She called out numbers: 6 feet 2 inches, 6 feet 3 inches. The man with the polo shirt wrote them down. Sandra said the fence exceeds the 6-foot height limit, and that is a violation. I walked over. I said the city code allows 6 feet, and the posts are set in concrete, so there is a small variance at the top due to settling. Sandra said the HOA rules specify 6 feet maximum at any point, and this fence is over. I said, show me the rule. She said it is in the guidelines. I said I requested the guidelines 2 weeks ago, and nobody sent them. She said that is my problem, not hers. The woman with the phone said we are documenting this for the board. I said good, I am documenting it too. I held up my phone. She looked uncomfortable. Sandra did not care. She said the fence is coming down and I am paying for it. She said the board is meeting tonight and voting to authorize immediate removal. I said you cannot remove my fence without a court order. She said watch me. They left. I called Mark. He said file for a temporary restraining order. He said if the HOA tries to remove the fence without a court order, that is destruction of property, and we can get an emergency hearing. He said he would draft the motion tonight and file it first thing Wednesday morning. Wednesday morning, I got a call from the Fargo Police Department. The officer said they received a complaint from the HOA about a safety hazard on my property. He said he needed to come out and take a look. I said, sure, come over. He arrived 30 minutes later. He looked at the fence. He said it looks fine to me. I showed him the city permit. He said as long as you have a permit, the city is not going to do anything. He said the HOA can complain, but they cannot make me remove it without a court order. He wrote a report and left. That afternoon, the management company sent another email. The email said the board voted to authorize removal of the fence, and they hired a contractor to do the work on Friday morning. The email said I would be billed for the removal cost, estimated at $1,200, plus the accumulated daily fines, currently at $800 for 4 days, plus a $500 administrative fee for emergency enforcement. Total, $2,500 due immediately. I forwarded the email to Mark. He filed the restraining order motion that afternoon. The hearing was set for Thursday at 10 a.m. Thursday morning, I met Mark at the courthouse. We went into the hearing room. The HOA attorney was there. He was a young guy in a suit, looked like he just passed the bar. Mark laid out the case. He showed the judge the city permit, the property survey, the doorbell video of Sandra's late-night notice taping, the body camera confrontation footage, and the email threatening illegal removal. He said the HOA is acting in bad faith and violating state law by refusing the records request and charging illegal fees. The HOA attorney said the association has the right to enforce its covenants, and the homeowner is in violation of the height restriction. The judge asked for a copy of the restriction. The attorney said it is in the design guidelines. The judge said, "Show me." The attorney pulled out a binder and flipped through it. He found a page and handed it to the judge. The judge read it. He said this says 6 feet maximum at the post, not at the top of the fence. The attorney looked confused. The judge said your own rule allows for variance above the post line. The attorney said that is not the board's interpretation. The judge said, "I am granting the temporary restraining order." He said the HOA is prohibited from removing the fence pending a full hearing on the merits. He said the homeowner has a valid city permit, and the HOA has not demonstrated immediate harm. He said the hearing is set for 2 weeks from today, and both sides need to bring all relevant documents, including the HOA plat map and the complete design guidelines. The HOA attorney said the plat map is confidential. The judge said no, it is not. He said HOA plat maps are not privileged documents, and the homeowner has a right to see it under state law. He said if the HOA does not produce it at the hearing, I will dismiss their case and award attorney fees to the homeowner. We left the courthouse. Mark said that went better than I expected. He said the judge is clearly annoyed with the HOA. He said we need to press the records request issue hard. He said if they are hiding documents, that is a pattern of bad faith, and it strengthens our case for attorney fees and sanctions. I went home and the fence was still standing. I felt like I could breathe for the first time in 2 weeks. I sat on the porch and looked at it. It was just a fence, 6 feet of chain link. It should not have been this hard. That night I got a notification from the neighborhood group chat. Someone posted a message about me. The message said I am a trespasser and a hazard, and I am ignoring HOA rules and putting everyone at risk. The message said the board is taking action, and residents should be aware. The message was posted by Sandra Wright. I screenshot it. I sent it to Mark. He said, add it to the evidence file. Friday morning, Ben came back to install the gate. He brought the latch and the padlock. We put the gate in and tested it. It swung open and closed smooth. I locked it. I stood there, holding the latch and the padlock, and I felt like I had won something small but important. Ben said, "You did good." He said most people fold when the HOA starts threatening. I said, I am not most people. At noon, Sandra showed up again. She did not have her clipboard this time. She had her phone and her body camera. She walked up to the gate and stood there, staring at it. I walked over. She said, "This is not over." I said the judge issued a restraining order. She said the judge does not understand the rules. I said the judge read your rules and said you are wrong. She said the board is appealing. I said good luck with that. She turned and walked toward the back corner of the fence. She stopped at the last post and pulled out her tape measure. She measured the distance from the post to the edge of the pavement. She wrote something on her phone. She looked at me and said the post is 3 inches over the property line. I said, no, it is not. She said, yes, it is, and I have proof. I said, show me your proof. She said, the HOA plat map shows the easement boundary, and your post crosses it. I said, let me see the plat map. She said it is not available to homeowners. I said the judge ordered you to produce it at the hearing. She said we will produce it to the court, not to you. I said that is not how discovery works. She said I do not care what you think. She said the board is going to prove you are wrong, and the fence is coming down, and you are going to pay every penny. I let her talk. I did not argue. I just stood there and recorded. She kept going. She said the board reviewed the survey, and it is outdated and inaccurate. She said the association hired a new surveyor 6 months ago, and the new survey shows the easement is wider than the old one. I said if that is true, then show me the new survey. She said it is confidential. I said you cannot withhold a survey that affects my property line. She said watch me. Then she said something that made me smile. She said you should have read the rules before you moved in, sweetheart. Same line she used 2 weeks ago. I thanked her in my head. I knew Mark could use that. She walked back to her car. Before she got in, she turned and said one more thing. She said the board is going to audit the entire compliance process, and anyone who filed false appeals or fraudulent permit applications is going to be held accountable. I said, sounds good. She drove away. I went inside and called Mark. I told him about the new survey claim. He said that is interesting. He said if the HOA commissioned a new survey and did not disclose it to homeowners, that could be a breach of fiduciary duty. He said, we need to get that survey. I said they are refusing to produce it. He said we will subpoena it. He said file a motion to compel and request sanctions for discovery abuse. That weekend, I spent hours going through my dispatch call logs. I am an EMT dispatcher, and my calls are recorded. I pulled every call I took during the time Sandra claimed I was violating quiet hours or blocking emergency access. None of the calls were about my property. I pulled the tow dispatch logs from the county system. I found 3 calls Sandra made to tow companies in the last 2 months. 2 were for guest vehicles at my house. 1 was for Ben's truck. None of them resulted in an actual tow because the drivers refused to proceed without police authorization. I compiled everything into a spreadsheet. Dates, times, call recordings, dispatch logs, tow requests. I sent it to Mark. He said this is huge. He said it shows a pattern of harassment and abuse of authority. He said we can use this to argue for sanctions and to strip Sandra of her committee role. If you are enjoying this story, hit the like button and subscribe for more wild HOA drama. Monday morning, I got a call from the management company. It was not the usual clerk. It was the president of the company. He said he wanted to meet with me in person to discuss a resolution. I said I am happy to meet, but my attorney will be present. He said that is fine. We scheduled a meeting for Tuesday afternoon at the management office. Tuesday, I drove to the office with Mark. The president was there. His name is David. He is in his 50s, gray suit, tired face. He said he reviewed my file and he thinks there has been a misunderstanding. I said there is no misunderstanding. I said your safety chair has been harassing me for weeks, and your company has been refusing lawful records requests and charging illegal fees. David said he was not aware of the records request issue. He said the clerk who handled my request is new and did not know the state law. He said he is waiving the processing fee and providing the documents within 5 business days. Mark said that is a start, but it does not fix the harassment issue. David said he is recommending the board remove Sandra from the safety committee and implement a new compliance process with oversight. I said, what about the fines? David said he is recommending the board void all fines issued during the dispute. He said the board meets Thursday night and he expects the vote to pass. Mark said we want it in writing. David said I will send a memo tonight. We left the meeting. Mark said that is a win. He said the HOA is backing down because they know they are going to lose in court. He said we still need to press for attorney fees and sanctions. I said, let's do it. Thursday night, I got an email from David. The email said the board met and voted to implement a new compliance process. The email said all fines issued against my property related to the fence dispute are voided. The email said Sandra Wright has been removed from the safety committee and her access to the homeowner portal admin tools has been revoked. The email said the board is commissioning an independent audit of the compliance process to ensure transparency and fairness going forward. I read the email 3 times. I could not believe it. I forwarded it to Mark. He said, congratulations. He said we still need to finalize the attorney fees, but this is as good as it gets without a full trial. I said thank you. Friday morning, I got a package in the mail. It was from the management company. Inside was a flash drive with all the documents I requested. The HOA plat map. The board meeting minutes. The safety committee charter. Sandra's appointment letter. And a folder of emails between Sandra and the board about my fence application. I plugged in the flash drive and opened the plat map file. The map showed the easement boundary. I compared it to my property survey. The 2 maps were identical. The easement did not extend into my lot. My fence was on my side of the line by 6 inches. Sandra was wrong the whole time. I opened the email folder. There were 43 emails. Most of them were Sandra reporting violations. Pool furniture left out overnight. Guest cars parked in driveways. Lawn mowing noise during quiet hours. Every single email included a recommendation for immediate enforcement and escalating fines. The board approved every recommendation without question. Then I found an email from 6 months ago. It was from Sandra to the board president. The subject line was Compliance Strategy Update. The body of the email said the safety committee recommends implementing a records request fee structure to discourage frivolous requests and protect board confidentiality. The email included a proposed fee schedule. $50 for processing. 25 cents per page for copying. 30-day review period for all requests. The board president replied, approved, implement immediately. I sent the email to Mark. He said that is smoking gun evidence. He said they deliberately implemented an illegal fee structure to hide documents. He said we can add that to the sanctions motion. I said do it. The next week, Mark filed a motion for attorney fees and sanctions. He attached the email as evidence. He argued the HOA acted in bad faith by charging illegal fees and withholding documents. He requested full attorney fees, costs, and a court order requiring the HOA to revise its records, request policy to comply with state law. The hearing was 2 weeks later. Same courtroom, same judge. The HOA attorney tried to argue the fee structure was a mistake, and the board did not intend to violate the law. The judge was not impressed. He said the email shows deliberate intent to discourage records requests, and that is a clear violation. He said I am awarding full attorney fees to the homeowner in the amount of $8,200. He said I am also ordering the HOA to revise its records request policy within 30 days and submit the revised policy to the court for approval. The judge looked at the HOA attorney and said one more thing. He said, if I see this association back in my courtroom For similar conduct, I will consider sanctions against the board members personally." The attorney nodded and said, "Yes, Your Honor." I walked out of the courthouse, and the sun was shining. I got in my car and drove home. The fence was still standing. I unlocked the gate and walked into the side yard. My daughter was visiting that weekend. She ran outside and asked if we could play in the yard. I said yes. She smiled and grabbed her soccer ball. That night I got a text from Ben. He said he heard about the court win. He said, "Good for you." He said, "Most people do not fight back." I said I had no choice. He said, "You always have a choice. You just made the right one." The following month, the HOA held its annual meeting. I went. The room was packed. David, the management company president, stood at the front and announced the new compliance process. He said all violation notices will now include a copy of the relevant rule and a clear appeal process. He said the board is implementing a homeowner bill of rights that includes access to records within 10 business days and a cap on copying costs at actual expenses only. He said the board is also creating an independent compliance review committee to audit all enforcement actions and ensure fairness. Sandra was sitting in the back of the room. She did not say a word. After the meeting, she walked out without looking at anyone. 2 weeks later, I got a letter from the board. The letter said the HOA commissioned an audit of the compliance process and found multiple procedural violations. The letter said the board voted to void every violation notice Sandra issued during her tenure as safety chair and refund all fines collected. The letter said homeowners who were affected would receive refund checks within 30 days. I got my refund check 3 weeks later, $800. I deposited it and took my daughter out for dinner. The fence has been up for 6 months now. No more complaints. No more certified letters. No more late-night inspections. My daughter plays in the yard every time she visits. She says it is her favorite place. Last week I saw Sandra at the grocery store. She was in the checkout line ahead of me. She did not look at me. I did not say anything. I just stood there and waited for her to leave. She grabbed her bags and walked out. I paid for my groceries and went home. The neighborhood is quieter now. The HOA still sends out the occasional violation notice, but they are reasonable. No more measuring tape ambushes. No more harassment. The board replaced Sandra with a new safety chair who actually reads the rules before issuing citations. I still have all the evidence: the doorbell video, the body camera footage, the email trail, the dispatch logs. I keep it in a folder on my computer just in case. Mark said I should write a book. I said, maybe someday. For now, I am just grateful the fight is over. I won because I kept records. I did not back down. And I had help from people like Ben and Mark, who refused to let the HOA bully me. The system worked, barely, but it worked. If you are dealing with an HOA that is abusing its power, document everything. Record every conversation. Keep every email. Get a lawyer if you can afford one. File formal appeals. Use the rules against them. Do not let them intimidate you into giving up. The fence is still standing. That is all that matters. Thanks for watching, and I will catch you in the next one.